You get the bright green table.
Merry Christmas.
Merry Christmas. Welcome, Judge. Thank you for joining us. As you know, I'm Amanda Carl. I am the Vice Chair of the 5th District Court of Appeals Judicial Nominating Commission. You've been in front of us before, so you know the drill. We'll all introduce ourselves, tell you where we're from. You'll have 2 minutes to give us any opening remarks. We'll fire away with questions, and then you'll have a minute at the end if you want to make any closing remarks. One new detail today, we do have Volusia Exposed videoing, so that camera's right behind you. And we'll go ahead and get started. Craig.
Craig Dyer, Public Defender's Office, Daytona Beach.
Good afternoon, Judge. Petra Brownlee of the Brownlee Law Firm.
Brett Ranton, shows Bowen in Orlando.
Andy Cordes with Great Office.
Good afternoon, Your Honor. Vince Citro at the Law Offices Portland and Citro.
And I'm David DeArmas, Kramer Price and DeArmas in Orlando.
Go ahead.
Well, the opening statement is always the hardest part for applicants here. So I was thinking in the car over, okay, make sure you tell them that you always follow the law, that you hate activist judges, and you read for the original text of the statute before you make any decisions. So that's all out of the way. So I decided what I wanted to focus on was a question that was asked by Chairman Sasso the last time that I was here that I don't think I gave a thoughtful enough answer to. So what he asked was, you have a very busy courtroom in the dependency court. I actually say it was my last day there. I'm going to General Civil, but I've been there for 3 years. Very busy, sort of a 3-ring circus all the time. He said, how would you transition from that incredibly chaotic environment into the monastic world of, I guess the word he used for the District Court of Appeals? And I think I answered that a little quicker than I should have, because ultimately when I thought about it, I thought that really is an important question for any trial judge that's here. How you're going to make that transition, or why you want to make that transition. So I thought it through, and of course that's one of those where I wish I'd given a better answer then, but afterwards when I thought it through, I thought there are really 2 things about being a circuit judge that challenge me. And I do them, and I handle them, but I don't think that they mix well with my personality. One is that I have a tendency to be a bit of a perfectionist, and I like to make sure that I read cases and statutes and give the right answer. In a courtroom that's as busy as the dependency court was that I was in, you really have to settle for being probably right most of the time. It just moves too quickly, and there's too much going on, and there's just too big a docket to take the time and make sure that your answer is correct. Proud to say that I've never been reversed in a dependency case, so I think I'm hitting it most of the time right on. The second one is that it's exhausting. When I walk through that door and there's 50 to 75 people in that courtroom, and then for hours on end, I'm just center stage, all eyes are on me and all conversation is directed at me. Being an introverted person, I can do that, but I am wiped out at the end of the day. So I think that I don't reach my highest potential in that environment, and I think I could reach my highest potential in an appellate environment where it's a more monastic. And so I think I can do either, but I think I've always been drawn towards that quieter environment. Literally at the end of the court day, I go to my chambers and I close the door and I put on some headphones and I just decompress from that expenditure of focused energy all day long, which is challenging for me. So I think I really am better suited to that monastic environment than I am to the chaos that I manage and have for decades. But so that would be my opening. Answer that question.
And I had the opportunity to vet you, which was a lot of fun actually, because of the kind comments were made by a number of people, including my law partner Steve Price, who I know we've known for a long time.
Many years.
And the adoption world. A couple of questions that have come up with a number of people who are applying that really matter to me. I'd like to see or hear your views on the PCA process, how cases get PCA'd, is that happening too often, not often enough? What do you think is being done or should be done at the appellate level with the PCA?
So the middle level appellate court has to take all appeals, some of which are well-founded and some aren't. So I think that it's problematic if you're just writing on something that's very well settled. I don't think that's necessary. But I do think there's certain times when a PCA shouldn't be given. I think when the question is novel, if arguments are being made to put forth a change in the way the law is viewed, I think you should write on that to settle that issue. I think if it's a reversal, it should have an opinion that explains why. I think that when there are issues where there are conflicts in other jurisdictions, I think you should write. And then I also think that appellate judges should use case citation opinions sometimes too, instead of PCAs, to just make that clear. But I also don't think that it's necessary to write on every single case and continuously run the risk of saying things that are going to cause confusion in something that's well settled.
Okay. Everybody kind of looks to me.
I've asked her so many questions
I
before, I thought I would give someone else a turn.
Again, great to see you. I know we've interviewed you a number of times, and we've had privilege, or I've had the privilege to talk with you outside of that a number of times about this process. And so my question, I guess I'd ask a couple of them here. Do you believe that it should be a requirement that the individuals that we send up to the governor have all had some type of judicial experience in their background in order to be on that list for the 5th DCA as a requirement?
I think it's helpful. No, I don't think it's a requirement. I mean, I think there are appellate attorneys out there who are phenomenal, and they understand this process really, really well. So no, I don't think it's a requirement, but I do think it's helpful. I think that the appellate courts are handing down decisions that impact the trial courts, and if they don't really know how it operates, they're at a disadvantage. And I certainly know that I've been on the bench almost 4 years now, and I thought I understood a lot of things about what the world looks like from that perspective, but I am often surprised by how my views have changed from the bar perspective and the bench perspective. So I do think it adds that dimension, and I think it's really helpful.
What do you think is the largest challenge to the court system being able to maintain the integrity of the court system or the independence of the court system?
The election system. I think that as in the trial court, I think that it is fundamental that you have to recognize that you are going to be standing for re-election, and we have things like the criminal defense lawyers anonymous poll of judges that can take down a judicial career by those kind of comments. So I think that on the one hand, it makes the judiciary accountable to people, but I also think that it creates some hesitancy for judges to perhaps, I don't want to say modify what they would do, but I think temper their thought processes to accommodate that. And it's always in the back of their mind. They have to, if they're running for re-election, then their mind's not completely on their job. They're attending campaign events at lunchtime and after work and worrying about those things for perhaps a year if they have an opponent. If they're in the criminal division, they're always running the risk of getting crossways with a state attorney who's going to throw in against them just, or public defender throwing against them just to prove a point. And I think that affects the independence of the judiciary. When I was a younger lawyer, circuit judges were rarely challenged. Sometimes they were a little rough, but they were more independent. I think that they didn't worry about what would happen in the next election cycle. I think that they said how they felt, and lawyers were more respectful of that system, and so I think that probably is the greatest challenge to the independence.
Thank you. And what's the longest you've taken as a judge to rule on a motion or after a trial?
Okay, so if we have anything under advisement for more than 30 days, we have to report it to the chief judge. I have never been on that list, so
Okay.
I'm pretty obsessive about. I take my inbox home every day. I don't finish it, and I would never want my name to be on that list. So I have nothing. In fact, I finished my division today, and I have 2 orders that are due, and they will be done this weekend. I snuck out of the Osceola courthouse with my Surface Pro and didn't give it back because I finished my orders this weekend. So.
Well, thank you.
Judge Strowbridge, good afternoon. When I read your application, I see that you have had previously in private practice, your focus was on family law issues, and that as a judge that you've been in the same area on a 50 DCA, obviously you'd have to deal with a whole range of civil issues as well as criminal. So what in your background or qualifications can you tell us or share with us would qualify you to deal with the entire spectrum of issues that might come before a 50 DCA judge?
Well, actually, I was only in family law for about 10 years. After that, I ventured into juvenile and adoption, which is much more, it still deals with family issues, but on a constitutional level. Termination of parental rights is really fundamental substantive due process rights. So that litigation practice was statewide doing that. But yes, always in that general area of family and juvenile, and not typically in the area of business. But I did some work in immigration, and I did some contracts work when I worked in assisted reproductive technology, which was developing contracts and protocols and best practice for fertility clinics and surrogacy agencies along those lines. So I did quite a bit of that as well. And then early in my career, I didn't actually start out in family law. I actually started out working for McGuire, Voorhees & Wells down Holland and Knight, and I did sort of a broad-based insurance defense and corporate practice with them for the first couple of years that I was practicing. But ultimately, I think that the strength that I would bring to the District Court of Appeals is not from necessarily the area of practice, but the focus. So I focused on constitutional rights, individual rights. I'm now transferring into the civil division for the purpose of broadening out the areas of law that I practice in for that substantive area. But you can learn the standards that apply in the substantive area. What you can't learn is an ability to analyze those cases and get to the root of the policies and the principles that are outlined by the legislature and make sure that they're applied in different fact scenarios. I guess is a skill you learn in law school, but you either have that ability or you don't. So when I taught at Barry, I think that's where I developed an awful lot of that, because when you're writing on the appellate level, you are in fact instructing and teaching, and that's part of what the purpose of that court is, to guide those lower courts.
Is there a rule of appellate procedure or a rule of civil procedure that you think should be amended or created that you think would make the system better? Is there any way in which you think the rules of appellate procedure or civil procedure should be changed?
I don't think that I've ever really focused on that. I think the rules are not developed by my court. I follow them, and so I guess I'm thinking of what. Nothing that that comes to mind as I'm thinking it through. Of course, I operate for the last 3 years in an environment that's a little different. We have the rules of juvenile procedure. Oftentimes we have all kinds of hearsay flying around the courtroom. That's a little challenging. I understand the reason for it, because it can be difficult to move quickly on issues affecting the safety of children if you don't allow some hearsay in there, but it can also be problematic. requires some careful, thoughtful approach to that, to make sure that you're sifting through that hearsay to see how much direct evidence you're getting. So I don't know that I would necessarily modify it, but I think it challenges me that I can literally have a hearing where I don't have anybody who was there speaking. I have a whole bunch of people talking about what they said. But that happens in juvenile in accordance with those rules, and that can create some challenges. So maybe if I was to pick one, I'd say I might want to see some thoughtful consideration of how do we make that process protect those children, but also have a little pure evidentiary base for some of that.
Okay, thank you.
So you can just listen to hearsay, it's like a violation of probation hearing in that regard?
Yeah.
You just
They
listen
just
to, but it can't be, is it like a VOP hearing where you just, it can't be the sole basis for your decision? Are there any
No,
parameters?
it can be the sole basis for your decision in
Really?
juvenile. I don't allow that to occur. I would often tell the lawyers, I'm not making a decision based solely on hearsay. Get me the protective investigator who was there, bring me the person the doctor who said this, at least get me a written report from that individual so I know it's their words.
Right.
But no, in juvenile it can literally be based solely on hearsay, and I assume it's just a policy decision to make sure that the court can react quickly if they have to.
Hopefully in the right way then.
I would certainly hope so.
Yeah.
There's a lot of damage you can do if you go in the wrong direction.
Yeah,
So,
exactly.
Well, Judge, I'll ask you one question. Is there a case that you have read recently that you thought was particularly well reasoned, and why?
well reasoned. I've been up to my neck in one that I'm struggling with is poorly reasoned.
Well, tell me why it's,
okay.
that's a
Right,
good
we'll
one
take
too,
it
that's
next
great
time.
too,
That might be
please.
better.
Yeah.
I'm struggling a lot to flesh out Simmons v. Perkins, which came out from the Florida Supreme Court in June. So this is a case that deals with the presumption of legitimacy for unmarried biological fathers. So for hundreds of years, the child born to an intact marriage is presumed to be the child of the husband. And now I taught on this topic for many years at Barry, talking about how as the culture has shifted and changed, we've seen some erosion of that presumption. But in June, the Florida Supreme Court came and just kind of gave it a gut punch, which I wasn't expecting. And I was expecting more of a gradual erosion, and instead they came out with a decision that opened the door for unmarried biological fathers to come in and create a tremendous amount of litigation in circumstances where there's a husband who's claiming the presumption of legitimacy to protect his rights to that child and to protect that marriage. And so it's challenging me on a couple of levels. One is that Justice Lawson wrote the opinion. I have a tremendous amount of respect for him, but he didn't deal head on with the fact that we have a U.S. Supreme Court case very closely related factually to this that went exactly the opposite direction. And while it's an older case, I don't know that the Florida Supreme Court can just ignore the U.S. Supreme Court on that. And I don't know how to balance that out when the U.S. Supreme Court's saying you go this way, and now the Florida Supreme Court is saying, well, no, we're going to go a different direction on that. Then when you take all of that and take it out of the paternity context and you inject it into dependency, where we have a husband who's there, who's saying he wants a case plan, he wants to work through the dependency system, and you've got an unmarried biological father who's also seeking to have reunification with the child. I can't reunify with both of them, and so I don't, and I'm left discussing now and bringing unmarried biological fathers back in from cases in which we told them, there's a husband, goodbye. And so now we're having to bring them back in, talk to them about the fact that, well, they don't actually have rights, but I may have mistakenly told them that they couldn't get any rights. And now, according to the Florida Supreme Court, maybe they can't. And then turning it back to them to expect them to do something about it, and I've got a child's life in limbo. What's a reasonable period of time that I give them to do something about it? So we have a lot of enormous jurisprudence on this issue, and then this case comes along and has thrown a monkey wrench into a lot of how the dependency court operates and how they, how to interpret that jurisprudence. So I've been dealing with that for 6 months now in the dependency system. So quite challenging.
Thank you. Well, we're here at the end of our time. It's always a pleasure to have you and to meet with us. If you have any closing remarks that you would like to leave us with, then please feel free.
I think other than to just say, I know that was really challenging for you guys to pull all of this together on such short notice and get it all handled. So Governor Scott gets his, I guess, last 50 CA appointment. But I appreciate your taking the time, and I definitely appreciate you holding this in Oviedo instead of way over on the coast. But that's it.
Thank you
Thank
so
you
much.
very much.
Happy New Year.
Happy New Year.
You too.